love for you to learn a little bit more about the Millbrae Anti-Racist Coalition and how our collaboration today came together. And for that, I would like to introduce Amy Lauer.
Thank you. Thank you, Darren. Hi, everyone. We are hybrid, and I want to thank everyone for carving out time to be with us tonight. It's a smallish group here, and I hope you'll feel free to ask questions. If you're online, put it in the chat. We'll monitor that and save time at the end for a brief, facilitated conversation about how did the information you heard tonight affect you? What would you like to do? And any questions, we'll do the best we can to answer them. So I am one of the steering committee members and original founding members of the Millbrae Anti-Racist Coalition. I won't spend too much time talking about it, but it's really been an incredible learning journey for me and a wonderful way to meet members of the community. We got together in June of 2020 after George Floyd was murdered, and a fellow community member posted on Nextdoor, does anyone want to get together and talk about racism and what to do about it? So we did organize in March and had some other events, and decided by August we would actually formalize a bit and name ourselves the Millbrae Anti-Racist Coalition. We've done a lot of educational efforts, cultural celebrations, tried to influence policy. We're not done yet, but we haven't been successful there. And I have led the book group, and one of the books we read was Color of Law, which was illuminating on many levels. So in November of 21, it was November 16th, I remember it, my sister's birthday, I got a phone call or an email from Joe. He said, hey, did you read the same article I read in the San Francisco Chronicle about Ladera? Ladera is in San Mateo County, and the citizens of Ladera went through extraordinary efforts to have an amendment passed that sort of struck out any racist language in housing deeds and proclaimed their commitment to diversity, equity, inclusion. So out of something like close to 600 homes, over 400 people signed and put forward this amendment. So we decided to get together, and Joe's done extraordinary research to bring the concepts, and not even the concepts, the history of redlining, restrictive racial covenants, banking, real estate, many industries sort of all somehow working together to exclude people from home ownership, home occupation, and building of generational wealth. So without much ado, I do want to turn it over to my partner, Joe. He and I have been on this journey with Darren and the library. They're incredible partners. So yes, do take Darren up on his suggestions. And I do hope that, just by raising awareness, sort of each one teach one, it's amazing. Like if you're very in it, you think everybody knows, but then I remember myself 3 years ago, I didn't know any of this. So if you learned something today, please do pass it on. And without much ado, here you go. Here's Joe.
Great. Thanks. And I'd like to say a special hello to the 6 of you that are on Zoom watching us, including my daughter, Karen. Hi, Karen. Have a fan there. So Karen mentioned the book, Color of Law. So what we're going to do to begin is watch I think it's about 15-minute video. It's called Segregated by Design, and it's a award-winning documentary film that's based on that book, Color of Law. As we saw in the film, and as we probably know, personally, housing discrimination against Black, Indigenous, and people of color was prevalent during the first half of the 20th century, right? We saw that in the film, and we've probably heard this. So early on in the 20th century, the segregationist policies were actually adopted by local governments through either ordinances or zoning that segregated neighborhoods and said that only certain people could live in certain neighborhoods, and it was a matter of law. That then was eventually overturned and deemed unconstitutional in 1917 by the US Supreme Court in a case called Buchanan versus Worley. They found that these municipal ordinances and zoning codes that segregated neighborhoods were a violation of the 14th Amendment, which provides for equal protection for all. And that court decision then prohibited governmental agencies from using legislation or zoning to segregate neighborhoods. But the segregation didn't end because it just kind of shifted from being a governmental action directly to being put into effect via real estate transactions. And it led to the use of private racial restricted covenants in these real estate documents. And that went on for about 10 years. And then there was a test case in the Supreme Court in 1926, but they found that these racial restrictive covenants were in fact not subject to the terms of the 14th Amendment and that they should be allowed. So this, of course, severely undermined that earlier decision saying that segregation was wrong, but it in effect created a loophole that it was okay to do it as long as it wasn't being done directly by the government. But if it was done through private agreements between individuals who were making purchases and people that created subdivisions, then that was okay. So that being the law and that being the case law, that was a very prevalent practice from the 1920s through the 1940s, and that is to include these restrictive racial covenants in real estate documents as a way to keep people out who didn't want to be included. And it wasn't until 1948 when another case came up. It was really the same question, but this time in the case of Shelley versus Kramer, the Supreme Court in effect overruled that earlier decision and said that these racial covenants were in fact unconstitutional and a violation of the Equal Protection Clause of the 14th Amendment. And so from that point forward, by that Supreme Court ruling, those racial covenants were legally unenforceable. So they still existed, but they weren't enforceable. But that didn't really totally stop them from being used, because unless someone were to challenge them, they could still kind of happen. And so even after this 1948 decision, either some of these covenants continued to be used or people used more veiled kinds of things like threats, like saying, well, you know, if you move it in a neighborhood, I can't guarantee that the neighbors aren't going to come and harass you or going to, you know, attack your kids or, you know, or do something to hurt you. So they did everything possible to make it uncomfortable for folks that weren't white to move into the neighborhoods. So this by itself didn't really solve the problem totally. It wasn't until 20 years later in 1968 when finally Congress passed a definitive law called the Fair Housing Act of 1968 that expressly prohibited the discrimination of sale, rental, and financing of dwellings and other housing related transactions based on race, color, national origin, religion, or sex. So from that point, they really were illegal and they couldn't no longer be enacted. But that didn't take away all the historical covenants that were all in these older maps and deeds that people had. So that language, which was originally contained when these real estate transactions took place, that language was still in place. And so that discriminatory language is a lasting legacy that persists even to this day. So what do we know about how this affected Millbrae? That's what I was wondering. So I went to the county recorder office and I started digging. First, I found subdivision maps, which is when, you know, the land was split up into the large blocks and housing tracts were built. So what I did first, I found the maps, and then once you find the map, then you know the people's names who were the ones that created subdivisions, and then you dig further into the records and you can find these things called CC&Rs, covenants, conditions, and restrictions that a developer can impose as part of their subdivision. And some of the things are just really mundane about, the size of the lot, or like, you can't have clotheslines outside, or, you can't paint your house pink or something. So some of the things are very innocuous, but some of the things that I found, and I'll show you, were quite shocking. So, and essentially I found multiple examples of subdivisions here in Millbrae, which when they were created contained these same kinds of racially restricted covenants that we've been talking about. And in fact, they still exist in those documents to this day, and are although probably hidden to you and not enforceable any longer, are still, attached to your properties. So I'm going to show you now and I don't know that I found them all. I stopped after a certain point because I got tired of doing it, frankly, but I found 5 separate examples of subdivisions in Millbrae where these CC&Rs were included, and they had express racially restrictive language. Excuse me. So starting with this first one, which, get rid of this. The first one is Millbrae Highlands. Now, the Millbrae Highlands is a neighborhood that basically runs between, say, La Cruz and Taylor, all the way from El Camino all the way up to Skyline. And this map here is just, it's called Millbrae Highlands #4, which was created in 1937. It includes a part of Hillcrest and Camino Alto. It's the area right around Taylor Middle School. So when I found this map and I found who created it, then I found this. Language that's attached to it. So I'm just going to read part of it out loud, just because it's hard to read, I know, on the screen. So this person, in creating this subdivision, they said, whereas it is desired to transfer and convey all the property shown on said map, subject to certain easements, restrictions, conditions, covenants, charges, assessments, obligations, and agreements, as hereinafter set forth, pursuant to a general plan or scheme of improvement relating to that certain real property. So everything that follows, and this is just an excerpt of what's in there, but everything that follows is basically attached to each of the properties that's shown on that map. And this is the language, oops. This is the language that I found. As part of this subdivision, it states that no portion of the property shown on said map and no interest in all or any part thereof shall be conveyed, transferred, leased, or let to, or held, occupied, or possessed by anyone other than a person of the Caucasian or white race. Furthermore, this indenture is upon the further condition and covenant that no portion of said property shall be occupied or possessed or used as a place of residence by any person not of the Caucasian or white race, but subject to the right of any occupant to have the customary and reasonable domestic servants of other races. So if you had a butler who was of another race, that was okay. But if you were living there, no. This is another example. This came later in 1940. This is called the Millbrae Manor neighborhood. It's centered on Hillcrest Boulevard and it's Hemlock Avenue, which is on the east side of El Camino, between El Camino and the railroad tracks. Again, I won't read these, but almost the exact same language here. No persons other than those of the Caucasian race shall be able to occupy. This neighborhood is Lomita Hills. This is on the northern part of the city, north of Cappuccino High School, around there, like Lomita and Bayview and Santa Clarita. Same language.
So Joe, it looks like what you've shown so far, each one of those is in these newly districted areas of Millbrae. It seems like every part of Millbrae that's now been divided for voting purposes had these trees in them, is that right?
Well, just in this period, I'll talk a little bit later when I get to the end about some of the things that I also found, but especially things that were subdivided in the 30s and 40s. That's where it was the most prevalent that I found. So Meadow Glen is, the area Helen and Anita Drive, up from Magnolia up to Tioga Drive. Same language. And the fifth example that I found was Millwood, where I used to live actually. My old house I don't live there anymore, but the house that I bought was on Millwood Drive. So Millwood and Paramount Drives above El Camino, same language. So this was common here as it was everywhere in America. It's not like it was something that just happened here. I mean, it was just commonplace. Now, I found when I looked at older subdivisions, I didn't find that language, and I suspect that possibly that's because maybe there were zoning rules or ordinances that were in place that already prohibited any people of color from moving in. And then from the 1950s on, so like the Meadows neighborhood and the Mills Estate neighborhood, which came in the 50s, that language was not there. So at least around here, even though, as I said, it was unenforceable, but it was still happening. It seemed like here in the 50s and beyond that language stopped happening. But definitely there's a block of time in the 30s and 40s where virtually every neighborhood. And this is a map of showing you how extensive it is. All these neighborhoods that are colored, Lomita Hills, Millwood, Meadow Glen, Millbrae Manor here, and Millbrae Highlands. That's a pretty good chunk of Millbrae. All those neighborhoods contain these racially restrictive covenants in the deeds.
Can we assume the same for San Bruno?
I would say yes. If it was in that same era, I would say yes. It's probably quite.
Also Birmingham or worse?
Yeah, I mean it was across America. It was universal. Those were times where it was around the time of World War II. There was lots of anti-Japanese and Italian and German, and all those sentiments were very prevalent. And so what I found is that language is still in your deeds. So now our next speaker is going to be from the county recorder's and assessor's office, Jim Izazari. He's going to tell us about some new changes that hopefully he's going to explain to us now make it easier for residents in these neighborhoods to work together to have this language expunged from the deeds. And I don't even know exactly what he's going to say. I'm really anxious to hear, but what I've heard is that there are some recent changes that make it easier. And then before I bring Jim on, I will add as well that in a lot of these documents, it says that these things apply to every property, and then they oftentimes had a deadline. But if there was an objection by either a half or 2/3 of the property owners, they would automatically renew. So, and then I found one where it said that they would expire in a certain date, and I think that was the Millwood example. I think those actually did end because the language in the subdivision document said that it would end as of a certain date. But most of them just automatically roll over, and so they're actually still on your property deeds. So Jim, I'm going to let you go ahead and share your screen and give us your presentation. I'm looking forward to hearing it. Thank you.
Very interesting, Joe, and thank you all for allowing us to be here. On behalf of Mark Church, it's our pleasure to work with our community members on so many different areas. Our motto is people first, and if there's one area that really does serve people is how we manage our clerk recorder's office and the variety of services that we provide. One of the areas that is really exciting, of course, that's new that we've touched upon, is the initiation of AB 14 66, which was passed in September of 2021, and took effect in January 2022, which allows a county clerk to be proactive in assessing recorded documents and for restricted languages and record modifications. So what we're doing here is basically having a proactive effort to assist our constituents and property owners remove these restrictive covenant modifications from their deeds. Moving along here, let's get some definitions in place so we understand basically what we do and what is being removed. It starts really with CC&Rs. The CC&Rs are declaration of covenants, conditions, and restrictions that are a description of rights and responsibilities that run with the property. CC&Rs are commonly found in common interest developments, condominiums, and housing cooperatives today in order to regulate the use, appearance, and maintenance of a property. As you can see, unfortunately, in the past, they weren't used just for that. They were used for, unfortunately, reprehensible purposes that these laws are now here to correct. Now, the next terminology that we kind of need to understand is, what is a covenant? A covenant is a legally enforceable contract imposed on a deed upon a buyer of a property. And so you have them both, which are covenants, conditions, and restrictions, which are, again, normally referred to as CC&Rs. Restrictive covenants enforce a standard of uniformity across development. For example, building heights, placement of fences, property maintenance requirements, and the type of uses of property that are typical requirements are found in restrictive covenants. Unfortunately, in the past, these racially restricted covenants were used as legal restrictions prohibiting the purchase of, lease, or use of property based on race, religion, ethnicity, gender, familiar status, etc. These restrictive covenants were primarily used to segregate neighborhoods, as Joe adequately covered, and so did the presentation that we just saw, to segregate neighborhoods under the auspices of protecting property values and other reasons that really were not valid, or in the final analysis were unconstitutional. It prohibited many races other than Caucasian to purchase, lease, or rent homes in predominantly Caucasian community. In terms of the history, and it was covered very well, but I'll just briefly touch upon it. In 1934, the Federal Housing Agency included restrictive covenants in deeds, homes. It ensured, again, unconstitutionally, basically restricting property use and the enjoyment thereof based on race, religion, and other illegal characteristics. In 1948, the Supreme Court deemed all racial restrictive covenants unenforceable. So we had a Supreme Court ruling that basically made it unenforceable, but it wasn't enforced. Until 1968, when Congress passed Title 8 and Title 9 of the Civil Rights Act, also known as the Fair Housing Act, prohibiting discrimination in the sale, rental, and financing and housing-related transactions based on race, religion, color, national origin, religion, sex, disability, marital status, and familiar rights. Those actually gave a legal standing for people to sue. They had the right to sue now if they were discriminated against. However, that was back in 1968. And unfortunately, many of those practices continued depending on the communities that were basically not following the law. So they, not only did they not follow the law, but these restrictive covenants remained in the property deeds throughout all of the states, but particularly in California and the United States. They ran with the property. Remember, a deed runs with the property. So those documents that had these restrictive CC&Rs, covenants and restrictions, were embedded into the deed, which through a chain of title passed on from owner to owner to owner. Even though it was illegal, they were still in the deeds. In 2021, AB 1466 was passed to expedite the removal of these restrictive covenants from California property deeds. AB 1466 is a proactive measure where both jurisdictions and entities that are responsible for issuing deeds, transferring deeds, etc., i.e., a title insurance company, an escrow company, real estate brokers, real estate agents, or association that delivers a copy of a declaration governing document or deed to a person who holds an ownership interest record in property to provide a restrictive covenant modification form. So the proactive measure is that now these entities have a duty to provide a restrictive covenant modification form, which then the property owner to be can proceed in removing that restrictive covenant from their deeds. Additionally, the bill authorizes a title company, insurance company, and county recorder, real estate broker, and other persons to record a restrictive covenant. So now we've moved into the age of enforcement and also the age of taking a proactive measure to remove these restrictions from our deeds. And there is a process that can be followed. It requires the county recorder of each county to establish a restrictive covenant program to assist in the redaction of unlawfully restricted covenants and prepare an implementation plan by July 1, 2022. One of the areas here that we have, the bill requires county recorders and so County Recorders Association will be also monitoring county recorders to actually get reports from local counties and submit those reports to the state legislature through our County Recorders Association to monitor how these plans are progressing and the effectiveness of those plans. Let's talk a little bit about the removal of unlawful discriminatory covenants on properties documents. The first thing that a person has to do, or a property owner has to do, is obtain a copy of the recorded deed. Once you've received that, once you do have that copy, and we have copies here, you need to seek guidance from a legal counsel or obtain services from a titling company to prepare the restrictive covenant modification of the original deed. Once you've done that, you obtain a restrictive covenant modification cover page from the county recorder or title insurance company. That cover page is then submitted in a packet form to the recorder for review and process. What we will do at that point in time is we will then forward it to our county council to review for form and format to make sure to ensure that it complies with all provisions of the law. We also have our website, which is really an excellent place to go to understand a little bit about the program and the process, but it gives an overview of the process that I'm describing. So by all means, do utilize our website. It's smcacre.org, and you can go to the recorder's office or any department. We have 4 departments here: the assessor, county clerk, recorder, and elections. And our website will direct you to any one of those divisions that you may need to get services from. The actual removal of the discriminatory covenants from property documents, you have to record a covenant modification. There are fees that are associated with that, but in San Mateo County, with respect to that recording, Mr. Church, as your county clerk recorder, has waived that fee. The normal fees for recording a deed are $5 to the first page and one each subsequent page. But again, for this purpose, we have waived those fees. There are other fees also that are involved in recording a document. There are, for example, we have the real estate fraud prevention fee, which is a fee that's in place to fight real estate fraud. It goes to the district attorney. That fee is also waived. You do not have to pay that fee. There's a $75 recording fee from the state. We also waive that fee. So we're making it very, very easy to have these unlawful discriminatory covenants removed from our deeds. For more information regarding, the actual processes and the laws, you can go to San Mateo County Department of Housing website under Fair Housing, which is at smcgov.org/housing/assessment fair housing. They too take an active role as part of county government to ensure that we have the ability for not only fair housing, but also to remove any restricted, or inflammatory, or discriminatory, or unlawful practices with respect to these covenants, conditions, and restrictions that are contained in these deeds, and to make sure that they are removed expeditiously and properly. So we make it as easy as possible for our constituents to basically take advantage of that program and that process. So on that note, I'll open it up to any questions you might have. I want to thank you for your time and for your interest in this subject, because that's the way things get done in a local community. It is the active participation of our citizens that really enables change to occur in our community. So thank you very much for being here, for doing this.
Yes, thank you, Jim.
You're welcome.
Okay, can you stop? There we go. Stop sharing so we can see that. So, I mean, I want to open up the questions. I guess I'm going to start because I like what I heard about not having any fees, but I don't understand why you would need to hire an attorney. Isn't there some kind of a template or something that can be created to, I mean, if the action is just to strike a certain clause out of a deed, why would you have to have an attorney?
Well, first of all, the form is relatively straightforward. However, when you're talking about deeds and you're talking about actual real estate transactions, we at the county clerk's office and the county recorder's office or county council are prohibited from providing legal advice. So what happens many times is folks come to the counter and have a legal question. The how, the why, the wherefore, how we can do this, or what does this mean in this particular provision of our deed? What impact is it going to have into the future? We are prohibited by law from providing legal advice. And it is a very technical and complicated process when you start digging into how that may impact, your particular situation. So we recommend that you work. Title insurance companies are great. They have legal staffs on board that can answer a lot of your questions. But we here at the county clerk recorder's office cannot answer or provide legal advice.
I understand. Now, but would you have any sense of, on average, how much would it cost then to actually go through the entire process, even though your fees are waived? How much would a property owner incur in expenses to accomplish this? Just
minimal. But what I would do, okay, is that I would work with your local title insurance company. They provide these services. They have customer service entities within title insurance company just to help in this area. So they are a huge provider of information, of very valuable and legal information with respect to how deeds are recorded and the work that they do. So I would look at your title insurance company because that's what they do every day. And of course, if you're working with your real estate broker or if you're working with an attorney, they too would understand that. But it mostly starts 9 times out of 10 out of the title insurance company and the real estate brokers that you're working with.
Okay.
Hey, Joe, on that topic, can you ask him if that's just for pending transactions? Because title insurance company, I can't imagine they're just gonna let you come in from insurance you got 10 years ago and service you for with no costs.
Did you hear that question, Jim? He's
No, I did not that clearly.
one of our audience is asking, okay, so if I'm in the middle of a real estate transaction, I have a title insurance company on board that I can work with. But if I just want to approach them, on like a cold call and say, I want to modify my deed, how willing are they to help in that case when we aren't actually, we don't have a client relationship with them yet?
It really does depend on the title insurance company. Title insurance companies survive and excel when they provide customer service. And you will see that most title insurance companies that I have worked with are more than willing to provide information. And they're not going to record a document for you. They're not going to do a chain of title search. They're not going to do something that really requires extensive legal research to come to a conclusion on. But what they will do is they will give you the guidance that you need to do that. One of the easiest ways to do it is to get a copy of your deed. And once you get a copy of your deed, we will give you the actual form to fill out. At that point in time, we would then, if you submitted it to us or if it was part of a transaction, we would automatically send it to county council to make sure that it is filled out as to its form and content properly for recording. So it's relatively easy to do that. It's when you start getting into the actual legal questions that you may need the assistance of an attorney.
Yeah, I guess I was hoping since these clauses were applicable to the whole subdivision, that there would be a way to expunge them from the whole subdivision in one fell swoop. I hear you saying it has to happen one property at a time. Is that how it works?
Exactly. That is the way the law is written right now. And that is that the individual is the one who has the responsibility to remove that restrictive covenant. We have the responsibility to remove it also, but to initiate it, it is basically at the property owner level and also at our level. When you're recording a document, we're going to provide you, and we see that there's a racially restrictive covenant, and we're going to provide you a form. But in terms of a blanket type of action, the law does not address it in that manner. It's an individual on a case-by-case basis.
Any other questions out there? I saw a hand in the back.
I was curious, does this expunge it completely, or does it make an amendment so that history still shows?
The question was, once this action is taken, is the language totally removed, or is it just amended? And the question was asked in a way because having the language there as a historical relic is kind of a good thing. So what happens to the language? Is it just totally gone, or is it?
What is eliminated is the language through redaction, and that redacted deed is then the one that is recorded. So it is redacted. The language is literally taken out. You'll have a black line going through.
Okay. Any other questions
So
or comments?
I have a question, just to get some feedback about, from anyone. Did you learn anything here? Was anything new? Or did you already know? Yes. So what was something that was struck you in particular, if there was some new information?
I couldn't hear the question. I'm sorry.
Yeah, it wasn't a question for you.
Yeah,
It was
Oh,
more It was more for the audience, yeah.
But for the people on Zoom,
Yeah.
and you can please put your answers in the chat. The question is, well, it's a two-part. One is, was there anything new that you learned tonight? And if so, what was something that's really stood out for you?
Is anyone monitoring chat? There's 17 unread.
Yes,
Okay.
there it is. I saw some hands.
Many of those that are here.
Yes,
I didn't know anything about this until Joe brought it up, but I'm really disappointed that this act doesn't do a wholesale cleaning up of the files. I mean, it's just.
For the whole subdivision, you mean?
Yeah,
With this qualification, if the fellow from the county or these days is true, and I'm not sure he understood the question, but if he did understand the question, then changing all of this, all it does is whitewash what was done, and no one, if I understood what he said, no one 100 years from now will know what the heck really happened. Is that what he said? I'm not sure.
Well, I think so, because Jim, the comment was that in a way, it's bad from a historical perspective if the language is totally just blacked out, because then people after us aren't even going to know as well what the history was of that particular deed. But so that's a comment.
Why another AV.
Well, first of all, under the Public Records Act request, that original language indeed would be available to be viewed. But once the restriction is removed, that will be the recorded document that's viewable by the public. So the information is there, but once it is redacted, it will not be viewed unless a PRA request is requested, or you can go and basically ask for that, and then we would be legally obligated to provide you the previous deed information. That also would be part of a chain of title search. So if you were to go to your local title insurance company and say, I want to know, I've owned this piece of property. I'd like to know who owned it right from day one. So I'd like to do a chain of title search. That too would bring that information up if requested.
Okay,
So
so what I hear you,
automatically, the documents that are going to be viewed online are redacted.
yeah. So what I hear you saying is that it creates a new document where the language is redacted, but the original documents also still exist in the realm of all the records.
Yes, that deed runs with the property.
I have a question about this article that Amy and I saw like a year ago, because and it must have gone through your office, because it involved the community of Ladera, which is in San Mateo County. They apparently went through some kind of process that it appeared like that they were able to expunge it from the whole community.
Yeah, expunge. So if any of you are interested, and Darren, if you don't mind putting it in the chat, if you just Google Ladera racially restricted covenants, San Francisco Chronicle, this article will come out.
Okay.
And what I got with my quick reread on my phone, which is not in depth, is that they put together a year-and-a-half volunteer campaign to get signatures for the majority of homeowners. So they got 391 of the 534 properties together. And it was difficult because a lot of properties were in multiple trusts, and it was just very complex. So what they did is they got San Mateo County to add a formal amendment. And it says to replace the titles of the lots with a statement avowing, quote, the Ladera community supports diversity, equity, and inclusion. So it's an amendment. So it's something that's added to. It doesn't sound like it's a replacement of, but I encourage you all to read that article, because I don't have thorough, deep comprehension of exactly what they did, but because what struck me was more, it was a year and a half. They raised $14,000 to do this extensive weekend week out, weekend, weekly campaign to get signatures and to actually locate all of these homeowners. So it's incredible grassroots, which of course appeals to me with Millbrae Anti-Racist Coalition, but I am interested in, we're interested in the process, but there are other things that are sort of glaring. How do you correct the decades, and you heard all the, forward-looking damage that has been done by government policies?
So like reparations.
Yes.
Yeah.
Yes.
How about that picture in 1968, fair housing law? So there is a fair housing law.
Yeah.
Yes.
So
So, I mean,
You have to sue.
I think what we've
Yeah,
learned
right.
is that, the language is totally unenforceable and it doesn't mean anything anymore, but the words are still there and they're still part of the record. And that's the part that hurts, it's not legally enforceable anymore, which is good, but the words are still there.
Well, and there are articles all the time about continuing practices. So you heard about was government policies, and then there were other activities that happened, the violence, people standing aside, people in positions of power helping to make decisions, or showing homes, or intimidating people who are looking at homes. And there are many cases, if you just do a quick search, of racially motivated injustice when it comes to when people want to buy or sell homes. Sometimes houses are under or over appraised. Discriminatory lending practices continue. Who needs to sign? What you need to put down? It's sort of endless in policies that shouldn't happen, but they do. And so beyond, that's why I just, anyway, I'll get off my soapbox. Yeah, there is a process for the actual deed. And there are pros and cons of changing. I think that the amendment idea in Ladero is very interesting because in a small community, a big percent of people were aware and said, we stand for this, which is not that, but then, changing people's lives, reparations, and also putting pressure on banks or whatever else. I don't have the ideas. I just wanted to bring forward information because ideas come from community groups.
I also wanted to say that after we're done, I encourage you to come up and look at the exhibits here. I have copies of the maps and copies of the documents, and you can read for yourself the whole document. And I've highlighted the racially restrictive covenant aspects of each of the deeds.
One last question for Jim.
Yeah.
So they said to do this, they waived all the fees, but it is required. You either have to get legal counsel or work with the title company. What do you have to have them give you to bring to the county clerk recorder's office to show you've done one of those two things? Does the county provide a form where a title company or a lawyer firm will sign off? Yes, we've provided counsel. You're free to do this.
So Jim, this question's for you. They wanted to know, is in fact a lawyer or a title company required to be a part of the transaction? And if so, how do they demonstrate that in fact happened?
No, to record a document, you do not need an attorney. Any person can record a document. There has to be what's called recordable sufficiency. So we look at about 25, 30 different elements of a recordation. And if it meets all of those, then we will record a document, and anyone can record the document. You do not have to be an attorney. What we will do, though, as I mentioned, with respect to the new law, is when you're recording a deed, and our staff will give you the form, the restricted modifications covenant form. So you can actually fill it out, return it with your deed. We then will send it over again to our county council to make sure that it is true to form and format If it meets all of those legal requirements from our recording perspective, it will be recorded without the assistance of an attorney. So everybody has the opportunity to record one of these without actually obtaining legal counsel. But sometimes it gets a little complicated.
Yeah,
And when
is
those
there-
legal issues come up or those questions come up, our staff is prohibited by law and also county policy from providing legal advice.
Is there any kind of a legal self-help book that could assist in this? Like a,
You know,
I know-
I would say the Legal Aid Society, I'm sure online, there's a lot of information out there that you could probably gather online. Without doing research, I can't answer that question, but I do know that there are legal resources out there that can address it.
okay. Well, I want to be respectful of people's time, and the library is going to close at 8 o'clock, so I want to give you time to come up and look at the exhibits. I want to thank you again for coming.
Thank you, Jim.
Thank Jim, Amy.
You're welcome.
Thank you all so much for being part of this, and hopefully it, raise your consciousness and give you something to think about. So, thank you.
Thank you.